Council, is anything else?
I have nothing on behalf of Mr. Dabney, Your Honor. Thank you.
Okay. So we have 6 a.m. curfew. Thank you, Mr. Dabney. You can step aside. The gentleman at DDC, what's your name, sir?
Quentin Denzel Willis, Your Honor.
Thank you, Mr. Willis. This is Magistrate Chupbag. Good morning. You're here on a criminal matter. Case number is 230-56946, sir. People State of Michigan versus Quentin Denzel Willis. You have an attorney. Go ahead, counsel.
Janice Stevenson appearing on behalf of Mr. Quentin Willis, who stands me waives the reading of information after the plea of not guilty be entered on his behalf. Mr. Willis has been advised of his rights, Your Honor.
Thank you, counsel. I'm going to enter plea of not guilty. Court dates are May 26, 2023. It is a probable cause conference followed by preliminary examination, June 2nd, 2023. Both matters are in front of Judge Jefferson. Mr. Willis, while this case is pending, you're not to possess any flammable liquids. Do you understand that?
Yes, Your Honor.
I'm writing this information on your paperwork. Also, sir, while this case is pending, you are not to go to the residence of, I believe it's the apartment building of 980 Whitmore, City of Detroit.
Yes, Your Honor. But that's my home.
Well, sir, I don't want you to say anything because you're going to have your attorney, Ms. Stevenson. She's going to address that matter.
Oh, sorry, Your Honor. I apologize.
That's all right. We have City Attorney Vincent. Go ahead, Esteban, sir.
Thanks, Judge. In this matter, which allegedly just occurred a couple of days ago, we're dealing with the first-degree arson charge. We're dealing with an individual allegedly that started a fire in an apartment complex, as well as a motor vehicle located right next to that complex. Here, Your Honor, we have the day prior multiple tenants in that building, as well as them giving statements that the defendant previously said, I'm going to burn this bitch down. In reference to the apartment complex he and those tenants were residing. Your Honor, we also have a defendant who was known by the tenants based on their statements to police that the defendant had previously caused fires in the complex that the tenants have been able to put out on their own without fire department involvement. Additionally, Your Honor, we have a defendant who made a statement to the police that when he gets intoxicated, he becomes violent, makes threats, and doesn't remember what he does. Lastly, Your Honor, we have green light video that's captured the defendant breaking a window to the van near the complex and starting that van on fire. Now, Your Honor, with all of that, the people would have been asking for a cash bond, but in addition to all of that, this defendant is currently on probation as a result of a conviction just 6 months ago for purchasing a gun without a license, as well as a controlled substance. And that originally was a CCW charge that ended up getting pled down to the purchase in the controlled substance charge. Now, Your Honor, looking at all of the investigative notes, the allegations, as well as the fact that this defendant is currently on probation, the people feel that the defendant is a clear danger to the public in this matter. Simply based on the video capturing the defendant starting the vehicle on fire let alone the allegation that he attempted to start this apartment complex on fire. Fortunately, nobody was injured in this matter. However, with that
No,
being
true.
said,
It's not true.
Hold on, Mr. Willis. Mr. Willis, hold on a minute, sir.
he still is in clear danger, and as a direct result, the people would be asking for a $100,000 cash, no surety bond. Now, Your Honor, if the defendant were to be able to bond out of that $100,000 cash that the people are requesting, we would be asking for a GPS tether as well as home trust.
Okay,
No.
Council Stevenson, Esteban, go ahead.
Thank you so much, Your Honor. In looking over the investigator's report, I think every trial lawyer knows about the lack of absolute reliability of the green light video. I say that just to talk about the likelihood of successful conviction on the that life offense, Your Honor. I don't know about how, whether or not these alleged statements are going to survive any preliminary motion to quash, Your Honor. So I don't know if that's going to help the people send Mr. Quentin Willis to jail for the rest of his life. One of the statements, I think, by one of the witnesses is that they don't know who set the fire. I don't know about the admissibility of anything about any prior alleged fires, Your Honor, which the fire department is not making mention of. So, taking into consideration the very serious nature of the charges, the fact that Mr. Willis, though he's on probation, is not on probation for any assaultive crimes, Your Honor, I would ask the court. I think that the GPS tether is probably a good idea. I think it'll give the authorities a way to keep tabs on Mr. Willis's comings and goings, which I believe assures the safety of the community, which the people have addressed quite adequately. He's not been convicted of anything from this case as of this point, Your Honor. So I think that prematurely incarcerating him, which is what's going to happen if you set $100,000 cash bond, I think is putting the cart before the horse. So I would ask the court to consider nominal bond. Of course, I always ask for personal bond. This court knows that, but taking the very serious nature of the charge in and of itself into consideration, I would ask for nominal bond. And we'd have no objection to the GPS tether. If you're going to do that, Judge, I think I would ask the court even to consider personal bond, because that'll help the authorities to know where Mr. Willis is. I am very concerned about the likelihood of successful conviction based upon the information in this investigator's report from the perspective of a trial attorney.
Thank you, Counsel Stevenson. I heard from both sides in this particular matter. Another bond condition is that allegedly Mr. Willis had indicated that when he drinks, he gets violent, he doesn't remember. So while this case is pending, Mr. Willis, there's no drinking of any alcoholic beverages. Do you understand that?
I don't drink, ma'am.
Okay.
So you understand, right?
All right, so Mr. Willis, as long, Counsel, Mr. Willis, while this case is pending, no alcoholic beverages. Do you understand that?
Yes, ma'am, Your Honor.
Okay. So so far the three bond conditions: no flammable liquids. You're not to go to the address to the apartment complex. This matter, sir. There's no drinking of any alcoholic beverages. But now we're going to deal with the issue as to the bond. Okay. I've read the investigator's report. I've heard the arguments from both sides as to bond representations in this particular matter. Allegedly, there have been statements made by Mr. Willis. Is that quote? Yes. Is that because he was upset in reference to a family member? Allegedly, he did make the statement. Is that part of the statement is somebody raped my sister, comma, I'm going to burn this bitch down, unquote. Allegedly, he also made some other statements. However, in this particular matter, Counsel Stevenson, I do believe any bond is an unaffordable bond. Is that correct?
Correct, Your Honor.
Okay. In this particular matter, he's going to get a $50,000 cash, no surety, no 10%. That's going to generate an unaffordable court date, which would be Tuesday, May 23rd, 2023, 9 o'clock in front of Judge McConigal. I do believe that Mr. Willis, he is a danger. If we are to believe what allegedly the statements involved in the statements made in the investigator's report is that if he drinks, but yet right now he says he doesn't drink, but is that if he drinks, he's violent and he forgets. So, but not only that, but there's also alleged statements in that Mr. Willis has set fires in the past, but because the tenants have put them out, there have been no calls to the police department. So again, bond is going to be $50,000 cash, no surety, no 10%. He's going to have an unaffordable bond. Hearing date for this Tuesday next week, May 23rd, 9 o'clock in front of Judge McConigal.
Okay.
Council,
Thank you,
anything
Your Honor.
else? Thank you. Thank you.
Just one other thing, this defendant is currently on probation, so as part of this, the people would be asking that this defendant, if he does get bonded out, immediately contact his probation officer regarding this specific question.
Okay. All right.
I don't have
Mr.
any
Willis?
objection to that.
Yeah. Mr. Willis, if bond is posted on you on the $50,000 cash, you are to report to your probation officer of this pending case. Do you understand that?
Yes, ma'am.
Thank you, sir. You can step aside.
Thanks, Judge.
Andre, Omar, Foster.
Thank you, Mr. Foster. Good afternoon, sir. Mr. Foster, you're here for case 2305691 People State of Michigan versus Andre Omar Foster, also known as Andre Foster, Andre O. Foster, appearance for the people.
Thanks, Judge. Good afternoon, Steve Vincent for the people.
Right, we're on PA 3665, on behalf of Mr. Andre Foster, waive reading stand. Foster's been brought to this.
Thank you both. Court waive formal reading and plea of not guilty. Mr. Foster, the court on these allegations scheduling 2 court dates, sir. You must attend both of them. You have a probable cause conference via Zoom, May 24th. That's a Wednesday, 8:30, 36th District Court, Judge Jefferson. You have a right to a preliminary examination the following Wednesday in person, May 31st, 8:30, 36th District Court, Judge Jefferson. May 24th, May 31st, Judge Jefferson, the 36th District Court. Understood, Mr. Foster?
Yes, sir.
Thank you, sir. Not guilty, please enter it on your behalf. Anything as to bond from the people.
This incident took place allegedly a couple of days ago. We're dealing counts, and as a result of visual notices, potentially 3 of those counts, Your Honor, are potential life offenses. In this particular matter, around 5:30 in the morning, shots fired, multiple shots fired at or around the Griner Street address. The police respond to that address, and they ask an individual standing on a balcony when they get there if he heard any gunshots. Responds allegedly yes. He heard the gunshots being fired, and they came from the rear of the address that he was at. Police investigate the rear of the building, Judge, and what they find is a vehicle with open doors and a tire iron on the ground next to the vehicle. That same night, Judge, around the same time, ShotSpotter also picked up a single shot at a different location, which was close by. So they noticed this vehicle with the doors open. They didn't notice anything else at that time. Go investigate the other location. There's nothing there. Police come back to the Griner Street address. When they come back, the vehicle that they noticed with the doors open and the tire iron next to it had the doors closed, and the tire iron was now gone. So the officers decide to run the plate of the vehicle, and it comes back to the defendant, who lives in that same address based on their investigation. They go up and they speak with the defendant. At that time, the defendant changes his story from the original story that he had heard gunshots in back. And he tells police he ended up firing shots up in the air in honor of his late mom. The police end up recovering defendant's gun subsequent to what defendant said. It had 5 spent casings that were found, and they issued the defendant at that time a citation, and then the police ended up leaving. However, the defendant wasn't allegedly honoring his mom. He was shooting from his apartment at 3 individuals that were attempting to break into his vehicle. And how do we know this? Because one of the individuals that he ended up shooting called 911 and ended up telling the police. So the police come back to the defendant's apartment, and now the defendant, the 3rd time around, under interview, end up telling the police what had happened. He ended up shooting at the individuals as they were attempting to break into his car. So, Your Honor, we have a confession from the defendant. We have an individual that is habitual in nature. We have a dangerous individual that decided to take it upon himself and use a firearm that he doesn't even belong having, and shooting at people that were attempting to break into his vehicle, which was 1 story down from where he was located. It's clear this individual is a danger to the community. Your Honor, at this time, the people would be asking for a cash bond in the amount of $500,000, no sure.
Thank you. Any response?
Yes, Your Honor, with regard to bond and advise, Mr. Foster is 50 years old, Judge. He's a lifetime resident here in the city of Detroit. He doesn't have any pending matters against him at this time. He's actually midway through disability applications. I believe he is disabled. Judge, again, he's not employed. Now, there are priors here. This isn't an issue of time, but when I take a look at these priors, it looks like it's been about 15 years since his last felony conviction. These are drugs in possession of contraband offenses. I don't have anything assaulted in his record whatsoever. I did have a thorough opportunity to read this investigative report. The court knows better than me, Judge. There's always 2 sides to the story. We're only getting one of them. I would ask the court to consider a reasonable bond on behalf of Mr. Foster. I understand the comments on the case are really serious, but I think the court will find it positive under the Constitution would be on for Mr. Foster.
He's below the guideline, 200.
But I'm hoping the court will consider a GPS, a high personal bond, home confinement, no contact. It doesn't seem that these are parties that have any reason to contact each other, no issue relationship.
Thank you both. Mr. Foster, these are the most very serious allegations, most assaultive allegations. I've reviewed your prior criminal convictions, and it includes a number of felony convictions, including a conviction for a felony firearm, which APA Vincent has pointed out. These number of felony convictions prohibit you from possessing and concealing a weapon. And here we have allegations not only that you were in possession of a weapon, but that you allegedly fired it off from your window into public areas and allegedly striking an individual victim in the hip with a bullet. And the court notes that information alleged in the investigator's report has been taken into consideration. You have your employment status presented by counsel is taken into consideration as it relates to ability to post bond. I don't have any capious history. But Mr. Foster, there is according to the court, a high likelihood of conviction. Count 1's a very serious allegation. It's a possibility of a life offense. As stated, you had no legal right to possess a weapon, and not only we have allegations that you're in possession of a weapon, but you use that weapon allegedly to shoot an individual in a public place where allegedly other individuals were around. And for those reasons, Mr. Foster, the court finds you to be a danger to the community, finds that a personal bond will not adequately protect the safety of the public. So the court setting an intentional, unaffordable cash bond You'll have an unaffordable bond redetermination hearing, Mr. Foster, on May 22nd. That's Monday, 9 a.m. via Zoom, 36th District Court, Chief Judge McConical. If you're able to post bond, you will not need to attend the May 22nd date. However, you're always to attend the May 24th and May 31st date. The May 22nd, 2023 via Zoom is an unaffordable bond redetermination hearing. During this bond, Mr. Foster, there's no use of any alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon, no weapons. If you're able to make bond, you will be fit with a GPS tether, and I would require you to be under house arrest. You're not to leave your home until told otherwise by a judge for any reason. You go home and remain in your home under house arrest. During this bond, no contact with beautiful Kelly, and that means no contact of any kind. No contact orally, in writing, through a third person at her place of residency, employment, or through any forms of social media. No contact with Miss Kelly. For those reasons, bond will be set in the amount of $275,000 cash, no surety. Anything from the people or defense? All right. Do you have any questions about your court date or your bond conditions, Mr. Foster?
No, sir.
All right. Good luck, Mr. Foster.
All right, we are on the record in the matter of the state of Michigan versus Daniel Cusick, 23987. And then also, we also have 23 W79215A and B. And appearance for the people, please.
Good morning, Your Honor. My case is P2114.
Good morning, Your Honor. Respectfully, Attorney Alawam, bond number 66874 on behalf of Mr. Daniel Cusick, Your Honor.
I'm sorry, what did you say after your P number, counsel?
On behalf of Mr. Daniel Cusick.
Oh, sorry, I thought I heard something else. Okay, well, your client has not come back out of the breakout room, so just. Just waiting for your client to come back out of the breakout room so I can have him place his name on the record.
Sure. Can we bring him out, Judge, or?
I just did, counsel. Yes, I did. I just asked him in the main room. I'm not sure if he's paying attention or not. Here he is. Okay, Mr. Cusick, please unmute and state your name for the record.
Daniel Van Cusick.
Okay, so I just want to clarify, is your middle name Van or is your last name Van Cusick?
My middle name, I'm sorry, ma'am.
No,
Yeah.
that's okay. That's okay. I appreciate you putting your entire name on there. I just wanted to make sure we had it correct. Okay, and so today's the date scheduled for the probable cause conference, counsel.
Correct, Judge. He's being presented with an offer from the prosecutor, Judge, which is a reduction to use under 7411. If he's eligible, he indicates that he wishes to avail himself of the offer, Judge.
Okay, so it's being amended, it's being reduced to a misdemeanor, controlled substance use, and if your client's eligible, the court would sentence him under 7411 status, correct?
That would be our request, Your Honor.
All right, and then that's MCL 333.74042B, is that what that says, right, Mr. Kazak?
Yes, Your Honor.
Okay. Okay, Mr. Cusick, please raise your right hand. You solemnly swear from the testimony you're about to give this matter to be the truth, the whole truth, and nothing but the truth.
I do.
Okay. And you heard the plea that was placed on the record, correct?
Yes, ma'am.
As to the amended charge of controlled substance use. Mr. Kuzic,
Yes, ma'am.
okay. I need for the background noise to be non-existent, okay? As to the amended charge of controlled substance use under MCL 333.74042B, how do you plead?
Guilty.
Please stop moving your device. It's making too much noise on the microphone area and it's killing my recorder's ears. All right, you've gone over your advice of rights with your attorney, correct?
Yes,
And you understand all of those rights.
yes,
You also understand that by entering into a plea, you'll be waiving some of those rights, specifically your trial and appellate rights.
so it's trial of what?
Your trial and appellate rights. Do you understand that?
Yeah, I'm waiving my thing for a trial. Yeah, I understand that. Yeah.
Okay, so I just need to make a record that you understand what those are and that you're waiving those rights. And you also understand the possible penalty as a result of your plea, correct?
Yes, ma'am.
That can be in this court, any other court or administrative agency. Do you understand that?
Yes.
And knowing all that, you still want to continue with your plea.
Yeah, I'm not sure. I really don't know. I never been through this, so I really don't know what's, you know.
Mr. Kusick, I did explain to you.
Sir, hold on. Sir, don't tell me you've never been through this. You have a prior drug charge on your record from 1997. So don't tell me you haven't been through this.
It wasn't a felony. I don't know, you know, I wasn't like threatened with jail time of 4 years or what. I have a marijuana charge. Yeah, a misdemeanor years ago. Yeah. Okay. Yeah.
So don't say you've never been through this, meaning the court system. And the plea is the same. The fact,
Okay.
Some
Yeah,
of
it's
the
just
stuff that I have to find out, please don't interrupt. Some of the information I need to ask and put on the record is the same as it was back then and for a misdemeanor. So you understand the possible penalty as a result of your plea to this reduced charge. Is that correct or no?
Yes, ma'am.
You do. You understand the penalty?
Yes.
Possible penalty. Okay. And you understand the 7411 status. You understand what that is?
Yes, ma'am.
And knowing all that, you still want to continue with your plea?
Yes, ma'am.
Do you want an opportunity to speak to your attorney a little bit further, sir, or are you fine?
I'm fine. That's just, it's fine. You're right. I've been through this, right? The word felony is what gets me, but yeah. But that's what the 7411 thing is. Okay. Yeah. Yes, ma'am.
No, the 7411 thing is not the felony thing, sir. But let me just say this, that when you've gone from marijuana to crack cocaine, that elevates it up a little bit, sir. So that's where you're at. So do you understand? You want to still continue with your plea?
Yes, ma'am.
Has anybody promised or anything, threatened you or recorded you in any way for you to enter into a plea?
No, Your Honor.
All right, and counsel, if you can please murder your client.
Mr. Kazak, can you give us the date, daytime
May
location?
8th.
Give you the what?
Be one moment.
One
Yes.
can speak at a time. One can speak at a time for the record. Counsel, you should already have this information. It's May 8th, Mr. Alawali.
Yes, sorry, Judge. On May 8th, in the city of Wyandotte, Mr. Cusack, were you stopped by the police?
Yes, sir.
And in your possession, did you have some cocaine?
Yes, sir.
And you were not supposed to possess that cocaine, correct? You did not have legal prescription or legal authority to possess it?
No, sir.
All right, defense satisfied, Judge.
The court is also satisfied that the plea is knowing, voluntary, and factually accurate. This occurred in the city of Wyandotte, correct, sir?
Yes, sir. Or yes, ma'am. Sorry.
Okay. All right, the court will accept your plea to the amended charge. Dismiss the original charge per the plea agreement. We're going to schedule this matter for sentencing on June 15th. Does that work for you, counsel?
Respectfully, Judge, that's on Zoom.
No, that will be in person. That's a Thursday. The
June
only reason that you're on Zoom today is because the court has made, has allowed PCCs to occur on Zoom.
Judge, can we do around 11? Is 11 possible?
11 a.m. on the 15th, yes.
Yeah.
And Mr. Kusick,
Yes, ma'am.
you are going to have to email in information by 10:30. So I'm going to give you the email address, so please write it down.
Okay.
27DC probation
Okay.
at wyandotte.mi.gov.
At wine.mi.
Yes, .gov.
Okay. And what do I email them?
10:30. You're going to email your name and phone number, and they will contact you for pre-sentence investigation.
Okay.
Actually, Judge,
If you were to test, I'm sorry, counsel, just one moment. If you were to test today, sir, what would be detected in your system?
Marijuana, and I get a prescription every month from the doctor. I drug test every month already for the doctor, the Suboxone.
Okay, and sir, do you have a valid prescription for marijuana?
No, I did, but when it became legal, I never renewed it, but I was thinking of, you're gonna have to renew it for you guys again.
Well, when did you last use marijuana?
Oh, probably last Thursday when I got out. Or no, well, yeah, I was in jail for 4 days.
And so then, when you were released from jail, you went and used marijuana?
Well, it was in my system from the Monday before, yeah. So, yeah, I did.
You got out of jail and you used marijuana?
No, it was in my system from Monday. I mean, it was, it usually takes 30 days to get out of your system.
Sir, my question to you was, when did you last use marijuana? And you said Thursday, when you got out. Not when did you test for marijuana? When did you last use marijuana? You just said Thursday when you got out of jail.
Oh, yeah.
So is that what you did, sir?
Yeah, I think so, yeah.
So this court gave you specific orders not to possess or consume any alcohol or drugs unless prescribed. And you get out of jail and you go use marijuana.
No, well. No, I didn't mean it like that, but yeah, I guess it's like a prescription to me. Like I said, I never renewed my prescription. It's like, I use it as a medicine. I'm trying to get my card. I'm getting my medical records from the doctor today to renew my card. I have my medical card here.
Counsel, why should I not revoke your client's bond?
respectfully, Judge, he understands now that he's staying away from drugs. He indicates that his system is clean except for marijuana. The sad thing is marijuana is readily available nowadays everywhere, but he's going to be staying away from that if he's ordered by the court, Judge. And he's employed. He's a single father. He does have 3 children The children ages are 3, 10, I'm sorry, 5, 10, and 15. So he's a single father. He needs to provide for those children, Judge.
He needs to follow this court's orders, counsel. If he's providing for the children, right, if he's buying marijuana, then how can he, I mean, he's using that money instead of providing for the children.
Well,
Mr. Cusick, yes, counsel?
he understands he's going to be staying away from any drugs, Your Honor. Is that correct, Mr. Cusick?
Yes, sir. Yes, yes, ma'am. I'm sorry. Yes.
Mr. Cusick, let me be very, very clear. You're not to use any drugs that you do not have a valid prescription for. That includes marijuana. And before you start wasting your time and money, let me be very clear with what this court requires. If you, since you do not currently have a valid prescription, you need to make sure if you're submitting something to the court that it's something prescribed to you by a treating physician, not walking into a marijuana clinic and contacting the doctor on staff and saying what the problem is and getting a prescription. Somebody that knows you and has a treating relationship with you. Do you understand that?
Yes, ma'am.
Okay, I'm also going to order you for random testing. So when you email into probation, they'll give you the information on that as well.
Okay.
Bond and balance of conditions are continued.
Thank you, Judge. Judge, the client, his vehicle was seized in the process, so I'm asking the prosecutor if he could call the officer in charge and assist with getting his truck back, Judge.
Well, that's not something that's before the court today for that, so that I'm gonna allow you, you can speak to Mr. Kazak regarding that. The court's gonna go off the record.
All right.
You need a breakout room?
Yes, Judge. Thank you.
Okay, that'll be back to breakout room 1, counsel.
Thank
Mr.
you.
Kusick, you're good to log off and email in. Okay, so